Hi, everyone, and welcome to Raw Law. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome, everyone. So today we're going to answer your questions live, and we're going to, get to as many questions as we can. We're going to try to help as much as we can because that's what it's all about. Our goal is helping serious injury victims and their families, and we are here for you. So let's get into it. I see we have a bunch of questions already. Let me just update it to live chat. And so the first question I see is from RG Society. And the question is, what are the important questions you should ask your attorney in a personal injury case during mediation or before mediation, just to make sure they are on the right path? Okay, so I've talked about this before. So if you're going to a mediation, one of the things that is essential is that you and your attorney are aligned in terms of your ultimate goal, right? A mediation is a chance to settle the case. So if you, for example, are looking for 100,000, right? And your attorney thinks the case is only worth like 30,000. Well, that's not going to work at mediation, right? Because he's going to try to get you like 30,000 and say, hey, take 25 because he thinks 30 is a good number, but you want 100, you want triple that, right? For example, or it could be bigger numbers. It could be you want 1 million and he's trying to get you like 200,000. So you want to speak, you want to meet, you want to be on the same page. That's the most important thing. But in terms of questions, there aren't really any questions because usually when a case is going to mediation by that stage, they have already done depositions, right? They already know who's at fault. They've already done, depositions of the plaintiff, depositions of the defendant. A lot has already happened. So everything's pretty much done, and now it's just a chance to settle. So it's either going to settle for the number you want or close to that number, or if it doesn't settle, well, then you're just going to have to go to trial. And, so that's basically it. Like, clients don't even have to show up to mediations. You can show up, but you don't have to talk at a mediation. A lot of clients don't even come. And then the lawyer just goes, tries to get the top number. And then the lawyer says, hey, I got you X. Are you happy with it? If the client says yes, it's settled. You get the money in like 30 days. So it's pretty straightforward. But if for whatever reason, right, they don't give you enough. See, I think the important thing with mediations is the lawyer and the client have to be aligned. So you should speak and communicate to make sure you're on the same page, that you're going for the same number. But also, you have to speak to the defendant, right, to the law firm and to the insurance company, and to make sure that they are on the same page as you, right? Because if you're going into a mediation thinking you're going to get like $1 million, and they're going in thinking, oh, we're not going to offer more than 20K, we're just going to try to tell them how bad their case is. Maybe they're going to, non-suit the case or discontinue it, or maybe we'll just get rid of it for 20K, right? So a lot of the times the defendants use mediation as a tool to dishearten you and make you think you don't have a case when you really do. So that's just a tool, a ploy, a tactic that they use over and over again. So you have to be careful with that, right? So you don't want to see, I have a rule. I don't even go to a mediation unless I have a good faith offer. So if I'm trying to settle a case for $1 million, okay, if they offer me 300,000, 400,000, that shows me that's good faith, right? I go to a mediation, I could probably settle it for like 700, 800. So that's fine, I'll do it. But if I'm, telling them, hey, this is $1 million case, and they're saying, we don't have an offer, let's just go to a mediation, why would I go? Now I committed myself to spend whatever number of hours of time. I have to pay the mediator, the judge, probably like, $1,000, $2,000. I waste my whole day, could be like a 5-hour mediation. For what? For them to tell me I don't have a case, for them to tell me, oh, we'll offer you like 5,000, 10,000. It doesn't make sense, right? And then the client gets upset. They're like, wait a minute, you told me you were going to have an offer. You told me. And then that's what they do. So they know that, and they use that as a tool to then destroy legitimate cases, to break the bond between attorney and client, make the client upset at the attorney, make the attorney upset. And so knowing that, you have to get a good faith offer. That's really the most important thing for the mediations. And then Mule Boy says, good evening, Mr. Frekhtman. I've been having an issue with having my attorney keep me up to date on the progress of my case. If I call the case manager, the phone goes straight to voicemail. And when I call direct to the lawyer or email, I don't get a response. This has been going on for 3 weeks or so. Just wondering if you have any advice. Starting to feel a little unimportant. Yeah, I mean, really, they should be responding to you. I mean, if you email them, if you call, if you could make an appointment, show up. If they're really not, communicating at all, and it's been like over and over again for many weeks or even, months, and maybe, you have the wrong lawyer. Maybe you have to think about switching over. But what can I tell you? I mean, lawyers should communicate with their clients. Now, sometimes lawyers get busy. Even me, right? Sometimes I get like calls from like 20 people in one day. I can't, get back to everyone at the same time, because if I'm working on a trial, then I have to be focused on the trial, right? Because that's a big thing. I have to prepare. It's for a jury trial. It could be it's the ultimate result of this case. Now, other cases need work too. They need depositions, but other lawyers in my firm could help with that, right? Or they need paperwork, but paralegals could help with that. So you have to be able to delegate certain responsibilities, and you have to be able to. But communication is vital. I mean, a case manager, that's their whole job, right? Is to manage the case, manage the client. So they should be contacting you. If the attorney's too busy, I mean, the attorney really should contact you as well. Maybe not like right away, but like you're saying, 3 weeks. So, you could also try sending them an email, sending them a letter and saying, look, I'm very upset. Either, I need better communication, or maybe I'm in the wrong place. Okay, and then Ali says, hi, Arkady. I want to know, what is a 50H hearing with the city about? I was in an MTA bus accident recently, and I would like to know if you can handle my case with the city, or if you can refer me to a good lawyer that handles this type of case. Yeah, sure. I mean, I can help you. Just text me, 347-566-9595. I just ask that, when you text me, just include your name. It could be just your first name, the brief facts of what happened, just so I can get a picture of what happened, and then also the injuries, the date of incident, and your city. But this sounds like you're in New York, right? And it's a 50H. So you're asking what a 50H is. So a 50H is like a preliminary hearing that the city or any city agency, like the MTA, that's the Metropolitan Transportation Authority, right? They run the subways, they run the buses. That's like the New York City Transit Authority. But the MTA is like the parent organization. So they're a city agency or a municipality, right? So they're entitled to a 50H. It's just a hearing. Usually it's a lawyer that does it. Before, it was even sometimes non-lawyers would do it, like employees of the agencies. And they just basically ask you your name, your background, what happened, your injuries, or if you have any prior injuries. And then they create like a transcript, and then they send you the transcript. So it's just like a deposition, but it's usually a little bit shorter than a deposition. But they do it because they want to, speak with you, and they want to find out, like, basically what happened, and investigate the claim, things like that, find out about your injuries. And then, once you file a lawsuit, you're going to have another deposition as part of the lawsuit. Now, sometimes you'll have both a 50H and a deposition. And sometimes the lawyer, if the 50H was very comprehensive, then the lawyer at the deposition, the defense lawyer for the city, can just say, you know what, I don't even need a deposition. I'm waiving it because I have the 50H transcript, because everything's already in here. But that's basically what it is. But yeah, just text me, 347-566-9595, and I'm happy to chat and help, and maybe I could help you with the case. Okay, and then Frost Midnight says, policy limits are $1 million in a tractor trailer accident. I was driving and I was sideswiped. The tractor was in the fast lane merging in my lane on a 2-lane highway. The speed limit is 70, and this is in Alabama, but I'm in Georgia. Lawyer going to demand the policy limit, but says insurance company might wind me down, but I'm not taking nothing less than the policy limits for my losses and harms. Why do lawyers tell clients that? Why do they tell you what? Why do they tell you that the insurance company might whittle you down? Well, I mean, that's just what insurance companies do. It's usually what the lawyer has experienced in the past. So, if the policy limits are $1 million and you say, hey, give me the $1 million, they're not just going to give you the $1 million, right? They're going to give you an offer. They might offer you 100,000 and then think you're going to come down to like 600. And then they'll say, okay, 200, take it. This is our top offer, or whatever, 250. If it was so easy that you could just go like, give me $1 million, lawyers would be, super. I mean, lawyers already are doing pretty well, but it would be so easy, right? Lawyers would be like, I don't know, the richest people in the world, and then cases would be so easy. There wouldn't be any lawsuits, there wouldn't be any trials, there wouldn't be any mediations, right? They would just pay you. So that's what they do. They always try to wind you down or lower you and drag you down, because they're for-profit corporations, and their goal is to pay out as little as possible. Their goal is to pay out zero, get the case dismissed if they can. But if they cannot, then just to pay out as little as possible. So they want to pay as little as possible, and they don't care, about justice. They don't care about true compensation or taking, accountability or responsibility and saying, hey, our policyholder did this. They changed your life. They created all these life-changing forever injuries. Oh my God, maybe we have to, be accountable and pay something reasonable. No, that's not how they work. They just want to get out of the case. It's just a complete corporate culture, business, money, finances. That's all they care about. So it's just the sad truth. So, but yeah, I mean, I'm happy to give you a consultation about that case as well. You didn't put what the injuries were, but I'm assuming if you want the full million, there's something serious like surgery or some kind of permanent injury. So I'm happy to consult if you want to text me. Hey, let me drop my number in the chat in case anyone wants to text me later. You could just text me, like I said, just the brief facts, of what happened, just like a sentence or two, so I could kind of see it in my head, picture it. And then the injuries, the city you're in, the date of incident, your name, just so I could put you in the calendar. Because when I schedule the consult, I'll put call with John or call with Barbara at 2:00 on Thursday, just so I could, you don't have to give your last name if you don't want to. And then we could do that. I'm happy to do a consult. Okay, and then Marquita says, got my 1099 form for my candle business. Can I give it to my lawyer to prove my lost wages? I have my EIN letter from the IRS and bank statements too. Yeah, I think you can, sure. I mean, with something like that, with something like lost wages, it's really straightforward. It's just like whatever money you were making, and then now if you're not making the money, and if the reason you're not making the money is because of the the accident, the injury, the negligence that the defendants caused in your injuries, then yeah, you just basically want to show your wages. Like I was making X, like $50,000 a year, and now I'm not. And then the economist will then calculate that into the future. That's where you get the big money, right? Because if you could never work again, and then they calculate it based on the pattern jury instruction. So like if you and the life expectancy table. So if your life expectancy is usually for a woman, it's 83. But right now you're only 40. Well, you have 43 more years, right, of life. But then work, usually people work till about 70, right, 65. So let's say 65 minus 40, that's still 25 years, right? So 25 years, and if you're making whatever it is, 100,000 a year, well, that's 2.5 million, right? So it could be pretty significant lost wages. And that's how future medicals work as well, except there the doctor will say, hey, this is the medical treatment you need, like physical therapy, prescriptions, future surgery, future surgery not every year, but once or twice, but prescriptions, physical therapy, neurology visits, whatever it is. And then you add all that up and it becomes millions over the course of your life to age 83, according to those life expectancy tables. And Come Along with Uncle Joe says hello. Hi, how are you? Good to see you. Marquita also asks, I made $38K my first month of business. I got injured right after. Is that 1 month valid for past, present, and future lost wages? Please calculate for accuracy. Well, you would have to get an economist to do that. I couldn't do that in my head, But yeah, you're saying you made $38,000 just in 1 month. So that's very good. So, because you had your own business, right? So you'd have to. But if you only had the business if you have, you really need a little bit of a history. What about what happened in 2023, 2022, 2021? A little bit of a history. If you only have 1 month ever, it might be a little tough, right? Because that could be speculative. Who knows, right? Well, maybe 1 month it's doing really well, and then for whatever reason, it disappears. So, but you could try. I mean, basically, that's usually what you need is just the tax returns, the proof of wages, like you said, 1099 tax returns, and also the economist to calculate everything. That is an expert that your attorney calls. And Leonardo is here. He says, hello, hi, how are you? And Marquito also asks, is Publix negligent for not calling an ambulance or medical assistance for me after I fell? The worker yanked me from the floor and immediately started cleaning up the beer boxes. I mean, you could mention that as part of negligence, but it's hard to sue them for that unless you have a doctor to say that, for example, you need to show that the fact that they didn't give you medical assistance is what caused your injuries, right? So, for example, you'd have to have a doctor say, well, if they would have called an ambulance right away, then I would have had much lesser injuries. I wouldn't have had the need for surgery. But because they made me wait for whatever it was, half an hour, and then called the ambulance much later, or yanked me because they pulled me, maybe that caused an additional injury. And now, that's what caused the injury. But I don't think you really need that, because if you fell, because I remember your case was you fell because of those boxes that were negligently left there. So you've already fallen because of a Publix negligence. So it doesn't matter which negligence. If it's their negligence, I think that's easier to prove, just their boxes being misstacked, than if they called the ambulance a little bit late. I mean, I'm sure they didn't call it right like 5 hours later. So if it was like 20 minutes later or whatever, or someone else called the ambulance, it probably isn't worth. You could mention it, in the trial, but it's not worth like changing the whole lawsuit to make it based on that. Okay, and Ricey says, Arkady, hey, how are you? Great to see you. John says, I won my lawsuit in Michigan against the city, who is self-insured, for $220,000. Now I have a facilitation in 2 weeks for PIP, but for medical and lost wages that have been stopped for 2 years. Can this be bigger? Yeah, I'm not sure. I'm not sure about that, because we don't really have facilitation for PIP in New York, so I'm not sure how that works. But if you won the case for $220,000, that's very good. And it sounds like if you're having some kind of hearing, whether it's facilitation, arbitration, or mediation with PIP, that's the personal injury protection. So that's the insurance company that pays for all your medical treatment. So you'd want somebody to do that, like your lawyer, because if they can get a lot of that covered by that insurance, right, then it doesn't come out of your 220, right? Because otherwise, the way it works is like if the PIP or the no fault doesn't pay you, then what happens is, the 220, they have a lien against that. So the attorney takes a third, right? So it's like what, 70 something. So the attorney gets his money or her money, and then whatever's left, the doctor can now say, well, this is the client's share, but what about my lien for my medical treatment, right? And then they come in and they grab a piece of your money. You don't want that. So it's better for you to do that facilitation and have that other policy pay for it. That's a different policy. So that's the way it is, I think, in Michigan and in New York. So there's a separate policy. So you have one policy that pays. In New York, it's $50,000 for all the PIP. And then you have the BI, the bodily injury, which, is always different. It could be 25, it could be $1 million, it could be whatever. So yeah, so that's how you want to do that. And then Sani says, finally caught your live stream again. Good listen while I'm driving home. Oh, hi. Okay, great. I'm happy to see you here. Thank you so much. And Ricey says, I'm on a trial page. Money doesn't mean anything to me anymore. Yeah, well, I mean, like, ultimately, that's what the trial is for, right? To get some kind of compensation, to get money. Unfortunately, there's no other, recourse they could do. They can't give you your health back, right? And they're not going to like punish the defendant in the sense that it used to be like eye for an eye. They're not going to like, injure the defendant, right? Because that's like not, that's like a brutal, old school kind of society from like what, barbaric or whatever, So that's like, that's civil justice. Civil justice is money justice. But that's an important topic to think about and an important topic to speak about, especially like when you're picking a jury, because you want to make sure that your prospective jurors that are going to be deciding your case are okay with that. Because some people are not okay with that, right? And then they're just not able to put money on to value a case through money. And then Alicia says, defense lawyer changed 60 days ago, and the defense still has yet to file a notice of change in representation. Settlement proposal was submitted after discovery as per prior defense lawyer request. Yeah, I mean, you could have your lawyer kind of try to speed it up, make a motion with the judge and say, look, I understand if the defense lawyer wants to change lawyers or if the defense wants to hire a new lawyer, they have that right, but they can't delay the case, through that means. They have to appear, they have to file whatever needs to be filed, finish up the discovery, go to pretrial conferences, whatever the next step is. We gave you a settlement opportunity. If you want to settle, let's settle. Let's go to mediation. If not, then let's get a trial date. So your lawyer should be able to file a motion so they don't delay too much. And Zafraz says, I had my second deposition last Wednesday for a prior accident 11 years ago. It took 30 minutes. 10 million policy, had lumbar laminectomy, left shoulder surgery, injection in the neck. What comes next? So you had a second deposition last Wednesday. But that was not for this accident, but for a prior accident that was 11 years ago, right? And you're saying it took 30 minutes. And you're talking about how much policy there is and what your injuries are. I mean, I don't know what comes next because I don't know what else has been done. If you've had your deposition, if your lawyer has deposed all the defendants, if all the paper discovery has been exchanged, meaning you provided everything like your medical records, and your lawyer has obtained whatever documents he or she needs to obtain from the defense, right? If everything's been done, and this was the last thing, there's just that they found out about a prior and they said, oh, let me question you about a prior that you had 11 years ago, and they took a 30-minute deposition, then you're all done. You just go on the trial calendar. But if there's still other things left to be done, like either documents or other depositions, then you have to do those. So I wouldn't know, right? I'd have to review your whole file. So I would say, speak to your lawyer about that. Yeah. Oh, and Ricey sent a sticker, some funds. Wow, thank you so much. I really appreciate that. We'll use that to better the channel, to make it even better, to answer more questions, and to do a better job for everyone. Thank you so much. I truly appreciate that. Let me see. What's the next question we have? Oh, Ricey is here. Okay. He says, I hate insurance companies. Individuals are now taking the law in their own hands because they are so darn stingy and cheap, ripping off the great American people every day in every way. Yeah, I mean, unfortunately, to some extent it's true, right? Like we saw it happen, like where that guy, Luigi Mangione, right, took the law into his own hands, and now he's being tried, and a lot of people are supporting him. So we'll have to see what happens with that case. That's a health insurance, but it's even more true with personal injury insurance and these civil lawsuits, like what we do, right? Because like these companies, like I think I just saw something on one of the social media networks or one of the articles, and they were saying in 2024, the insurance industry had a record-breaking profits, like 93 billion, like some of the individual companies, whether it's State Farm, Geico, 93 billion they're making, right? And they're still like not paying fairly, delaying, right? Just kind of doing this to people. So unfortunately, it really should change. There should be some rules, at least like the bad faith rule that I talk about, so that you could open up policies if they're not going to pay fair value based on the policy limits. At least that should be everywhere. But hopefully there is some change coming, because I agree with you. It's not fair very often. And sometimes, they skirt the rules. Like I was looking at some cases today, and it's like a big truck, right? That's like one of the delivery service partners or delivery service providers for big companies, right? Like Amazon, right? For example. But what they do is they say, oh, but this is being owned by a different company, I guess a company that enters into a contract with. So even though they're delivering like Amazon products, they're trying to say, oh, this particular truck only has 25,000, which is like ridiculous, right? How could you say that when you're working for, a company like Amazon that has billions that should have huge insurance limits? But see, they're always trying to do something like that. Or Uber, the same thing with Uber, right? Uber says, oh, if you ever use the Uber, if you click to use the Uber, well, you've signed away your right to a jury trial. Now they want to just take it to arbitration. And guess what? Those arbitrators are their buddies that are going to lower the amounts. And, so They're just looking every way they can to screw over people. So that's what I don't like about it. Okay, and then Alicia says, waiting on a reply to the settlement proposal or to schedule mediation, but cannot do so until notice of change from the new lawyer. Yeah, well, you could probably just have, like I said, your lawyer file a motion and say, look, this is something that should really just take a day or two, right? What is it? Notice of appearance, notice of a new lawyer. It's just like, hello, I'm Joe Blow. I'm the new lawyer. I mean, what's there to do? It should take literally 30 seconds. He's already delayed it 60 days. So if he keeps delaying it, I mean, the lawyer should write him a good faith letter, email, call him, and then say, look, I called, I sent an email, I did all these things. He's just not responding. So look, I need the judge to force it. And then the judge will say, okay, you have whatever, 5 days to file your notice of appearance and change of lawyer, because that's not something you can't use that to delay a case like 6 months. That's not fair. And then Mike says, hey, how long does it take for a judge to make a ruling on a motion for summary judgment? New York City, Manhattan, civil case. Thanks for all you do. Sure. So usually it's not too long, usually like about 30 or 60 days. It could be a little longer. I've seen some delays with New York City, unfortunately. Even just to get a preliminary conference, sometimes people are waiting even 6 months or long periods of time. But I would think on a motion for summary judgment, it shouldn't be too long. But there's not really any hard and fast rule. After COVID, the courts kind of slowed down, and unfortunately, and there have been some delays. But I would also follow up, maybe call the part, have the lawyer send a letter, just make them know that you're waiting on it and you want to get a response. And IGOD says, on average, when a lawyer puts a demand letter, what do they normally think they'll achieve? From at least a third or 2/3? I've read different opinions in articles. Oh, you mean in terms of like the number they put in the letter? I mean, yeah, like it just depends, right? So some lawyers, they basically do that, right? They make a demand. And I know some lawyers think that it's usually about, you get like about a third of what you ask for. So for example, if you're trying to settle a case for 1 million, ask for 3 million, and then they'll give you 1 million, which is a third of what you asked for. But I don't like to play those games. I just usually just send a settlement opportunity letter and I put in there, hey, just pay me the policy limits, or if I feel like the case really isn't worth the full policy, because sometimes you might have a case where the policy limits are like 10 million, but the case isn't a $10 million case. It might be a $500,000 case. So I'll put like 500, but pay it within 30 days. And if you don't, then it'll go up to 1 million, or it'll go up to whatever. And you just stick to your guns and do it that way. That works pretty well. I've seen that, work, and the insurance companies get, scared. It always does something. Either they respond and they start negotiating and they pay, or they fire their lawyer and they start hiring like other firms. But it usually always leads to something, right? It stirs things up. It stirs the pot. So I like that approach better. And in that approach, it's more like whatever you put in the letter, that's the amount. It's more of you're giving them an opportunity or a chance to be fair, to settle, and you're saying, hey, I think fairness is X, like 500,000, and then pay that. And if you don't, that's fine. But then at trial, it's not going to be, this opportunity is going to be gone, right? I'm giving you this chance. Now it's only for 30 days. So at trial, it's not going to be 500,000 anymore. It'll be 1 million, and then they don't like that, right? Because instead of them being able to, like we were saying earlier today, whittle you down, right, and drag you down into the get it as low as possible. Now, guess what I'm doing? I'm doing the opposite. I'm saying, hey, pay me 500. You have this chance. No, it's going to be 1 million. No, okay. By the time I get to trial, it's going to be 3 million. I'm going the other way, and they don't like that. They're like, wait a minute, what's happening? Basically, you're flipping the script on them. So, and a lot of lawyers who use that have done very, very well. They've settled cases for, I think I did a video about that one case where they used that method, and they started with, they could have settled the case. I mean, the insurance company had that first opportunity was 700,000, and then the case ended up settling for like 27 million, because they just didn't take the opportunity when they had it. Yeah. So let me see. Gatry says, hello, Mr. Arkady. I'm still hanging in there, sir. Oh, great to hear you. Great to hear from you. All the best. Yeah. Let's speak. Maybe text me, and we'll set up a time to chat. Zafraz says, my case is going to trial calendar in March. I'll be going to IME in 30 to 60 days. When should we expect mediation or settlement offer? It's not really like a time when. It's just whenever. The settlement offer could be at any time. It depends on how your lawyer, like whether your lawyer sends one of these settlement opportunity letters, whether they're calling and trying to settle, whether they schedule a mediation. A mediation doesn't always have to happen. It depends on where you are also, like what state. Like in New York, mediations could never happen, right? Unless the lawyer calls the other side and they both agree on a mediation date. They have to both agree on a judge, and they have to both agree on the parameters. Like I was saying, like I don't even want to go to a mediation, right? If I'm looking for like $1 million, but they're giving me like 50,000, what's the point of going? So I want to see a good faith offer first. But if there's a good faith offer and then it looks like, hey, there's a real chance that this case can settle and it can settle for a fair number, sure, I'll go to a mediation. That's fine. So it just depends on how your lawyer is positioning everything. But from what you said, it sounds like the case is, if you're going on the trial calendar in March, depending on where you are, it could be another year or so, maybe a little more until trial. So now is the time to do like settlements, mediations, maybe some pre-trial conferences, things like that. And Ricey says, please, people, don't settle for less. Take all insurance companies to trial, jam up the system. Yeah, I mean, people should get fair value considering, right? Because what was taken away is so valuable and people's health is taken away, so then the equal trade dollar value of having your health taken away, what was taken, and also you have to think about what was left, because before you had like a full, let's say, brain, full body, full health, and now you have maybe half that, right? So that has tremendous value, absolutely. And Brandon says, hi, I'm in Florida. My deposition is scheduled for May 22nd. Also, I've seen online, I have a differentiated case management hearing. Have you ever heard of this kind of hearing, and what's the purpose? Yeah, I think it's just kind of like a preliminary conference, because case management is basically when they try to manage the case, which means like make sure all the documents get exchanged, all depositions get done. I have heard of that term, differentiated case management. You probably should ask your lawyer specifically what it's going to be at your hearing, because there's different things. But usually it's just like a scheduling order to get like your deposition done, documents that the other side may want before they take your deposition, which is mostly your medical records, right? They want to make sure they have all of them before they question you, because if they get them after they question you about, they can't depose you again about the same injuries, right? Only if you have an additional surgery later. So they want to make sure they get all the records before they question you. And the same thing with your lawyer, right? If your lawyer is suing the defendants, whatever kind of case it is, I don't know if it's a car crash or it's trip and fall, but it doesn't matter. They want to get all the documents, like the safety documents, so they can question the defendants about the documents. That makes the case stronger. Okay, and then Frost says, the trucking company has so many bad views for keeping false logs and bad stuff about the drivers. When I search the business on Google, it says permanently closed, the reviews wiped away. Do attorneys keep track of the trucking company reviews? I mean, not really the reviews, but there are other sources. Like, for example, you can get the Federal Motor Carrier Safety Act, and that will, if you get all the logs from there, and then you can get the safety record. There's something called SAFER. You can get it online, and it'll have like how many times it's been out of service, what percentage is that compared to the average, is that below average or in line, or is it above average, things like that. So then you could use some of those, and you could depose a corporate representative about their safety manual, whether they have a safety director. But if it's the whole company is closed, it might be a really small trucking company. And if they use like false logs and hire bad drivers, you'd want to ask them about their hiring practices. You'd want to ask them for copies of their logs and check with an expert, and the expert could help prove that they're false, things like that. But yeah, you might be able to, try to use reviews too, but usually it's not the reviews that are the paramount thing. Usually the paramount thing is going to be some of the Federal Motor Carrier Safety regulations, as well as the CDL manuals that talk about the rules of the road and things like that. And Ricey says, ridiculous that some of these people make really injured people with brain damage to a gosh darn depot. Yeah, no, it's terrible. It's terrible, absolutely. And then Jonathan says, hi, thank you for answering our questions. My brother got back and neck surgery and possible surgery and the hips, but now we have a problem. He got detained by immigration. Oh, I'm sorry. And going back to my country, that means we lose the case or his wife can still continue with the settlement. Well, it also depends on what stage the case is in, right? Because if he's already been deposed, then you could still possibly try to settle the case. But yeah, if he needs to be there, like for example, if there has to be a trial and now he's no longer in the country because he was deported, then it's an issue because without him, you can't have the case. Now, some jurisdictions allow for depositions by Zoom, a lot of people. So you could maybe take a deposition by Zoom. But ultimately, if the insurance company lawyers find out about it, right, they could say, well, don't pay on this one because, ultimately, if we go to trial, he can't come for trial unless the judge allows him to testify in trial by Zoom, right, from another country, but he might not allow that. So, yeah, it's tough. So you might want to settle the case now before, they find out about this, like the insurance company and the defense lawyer. And Bear says, do you know any good trial lawyers in Waterloo, Iowa? My attorney agreed to part ways and he said he would waive his fee rear-end case from 2023. I texted you before, but not about good lawyers in my area. Yeah, I do. Just text me again. I know some really good lawyers in Iowa, actually. I could recommend like one or two firms that are really good. I don't know if they're in Waterloo, but I think they do the whole state. And they're amazing lawyers. They've gotten a lot of multi-million-dollar results, like even crazy number, like 10 million, 20 million. So yeah. Just text me again. Let's chat. I think I remember this text. Yeah, I was going to call you maybe tomorrow or Thursday. Because I have to catch up with some of my consult calls. I've been a little busy this week. But let's speak, or I could just text you the information, or I could help have them call you, coordinate everything. I have a intake team. So my intake team helps me coordinate some of that stuff and put people together with lawyers all over the country. Okay. And Ricey says, Arkady works with some of the top attorneys in the United States. Top Trial 100 Lawyers Association. Yeah, definitely. I mean, I know a lot of the really good lawyers. And the other thing I do is if I don't know a lawyer in your city, like in Iowa, I know lawyers. But like if I don't know a lawyer somewhere, right? Like say you call me from, I don't know, Hawaii, right? Or I don't do a lot of work in Hawaii. So I might not know. So what I could do is I could go to the verdict search, which has the actual public results, like the settlements and the actual jury trial results. And then I could look in the last, like say 10 years, your type of case, let's say you got hit by a bus, right? And your type of injury, like a fusion or whatever you have. And then I can see, hey, which lawyers are getting the top verdicts? Hey, this one got 7 million, this one got 6 million. And then I can get you one of those lawyers, right? Because that's what you would want, essentially, is like the lawyer who gets the best results, right? For your type of case, whether it's a car crash, slip and fall, construction accident, whatever it is, medical malpractice, right? And for your type of injury, like they know, like either they know trucking or they know like how to handle brain injuries, because those are very, very specialized areas of law. And if you don't know how to handle them, if your lawyer doesn't know how to handle them, that could be the difference between $1 million case and like a 10,000 or a zero. It could make a big, big difference. They're very, very highly specialized areas of law. So yeah, I'm happy to do that, and I've done that for people before, where I research it and then I send them the results, and then I contact one of those lawyers for them, or they contact it directly, or the lawyer calls them, and we kind of set that up. So I'm happy to do that. I think that's a good help for people. Okay, and then Moss Def says, do you think the new administration and policies will impact how insurance companies calculate and settle personal injury claims going forward? It's hard to say. We've already had this president before, right? Like 4 years ago, we had 4 years of Trump, right? And I think back then, from what I recall, personal injury cases were actually pretty good. I mean, there were some places that were very, very, conservative, very, very Republican, and they were tough to get large verdicts in those jurisdictions. But it's always been tough in those jurisdictions, no matter who the president is, right? So, but lawyers did very well under the first 4 years of Trump. Trial lawyers, they got a lot of really big verdicts. It just depends. You just have to kind of understand people, understand their values, and kind of, present your case in a way that aligns with people's values, with what the jurors want to see. So I think we should be okay. As long as the case has merit and it's a real case with a real injury, I think we should be okay. And then Preacher says, do you solely depend on past settlements of other cases similar to the type of case you have now to value your case, or is it another tool you use to determine the value? Well, I mean, it's basically not just that, but that's like a big factor, because if you have a very similar case in the same jurisdiction with similar injuries, similar liability, and they've already gotten X, then you could say, well, that's kind of like the baseline. And you could do better, right? If you go to trial, hey, it doesn't mean you can't do better. But, if you have a lot of verdicts, like, for example, if you have a simple case like an arthroscopic, let's say, surgery to the knee, and it's a simple like car accident and there's nothing else. Well, a lot of lawyers settle those for even like 50 or 75,000. Now, if you have a really good lawyer, they work it up. Assuming the policy is big, somebody else might be able to get like 100, 150, even 200, 300 potentially, right? So I think that's an important thing. But I think the other important thing to consider is just the overall impact on someone's life, and getting to know the person, and getting to do like a deeper dive into the person, who they are, their values, their whole like biography, how this injury has affected them, and also their life, right? Their immediate life, like their friends, their family, their wife or husband, their children, their job, right? Because all the different parts of their life. And then if you really could show that also kind of drives value, makes the case worth a lot more. And then Ricey says, Miss Steph, very great question. Yeah, no, that's a good question. Absolutely. And Kevin says, can I ask, what is the most you've won for your client and what is the least, including loss? Would you be able to give some detail? Well, the most, you mean like the most we've won like in a trial? I think one of the biggest ones we've had was that case recently that we did, right? A few summers ago, we got 3.5 million. That was one of the bigger ones that I could remember recently. We've also had others that were close, like 2.8 million and another one for 2.2 million. I think once we had a case where we went to an inquest and it was over 4 million, but we didn't actually get the money because it was just an inquest, and we had to follow through on collections, and it turned out the people didn't have enough money to pay the judgment. And then in terms of the least, I mean, we've settled cases sometimes. When I first started, I was doing a lot of smaller cases, like little fender benders, and I was settling them for like 10,000, 5,000, 7,500. And yeah, I mean, I've had cases that I've lost as well. Like every lawyer has cases that they've lost, I think. If anyone says that they've never lost a case, they're probably lying. I can remember a few. Like I remember one that I lost when I first started back in like 1999. I think it was my first trial, one of the first trials. Maybe it was my second trial. But it was a tough case because the lady tripped and fell, but she tripped and fell in her own kitchen. But she had this tile. She was renting the apartment. It was an apartment building in Manhattan. And, she had this tile, and the tile was a little bit lifted. And she had complained, hey, can you come, the super, fix the tile? But they didn't come. Whatever it was, a few weeks passed, and then she tripped and she fell on the tile. But it was in her own kitchen, so they were saying, well, you should know about it. It's your kitchen. You're the one who called us. So anyway, so then the jury didn't give her any money. They basically said it was her own fault, I guess. So that's an interesting topic too, because now the law kind of changed on that, right? Before in New York, you couldn't move for summary judgment. But now the law has changed where the culpable conduct or the contributory or the comparative negligence of the plaintiff is separate, right? That goes to damages, meaning if the plaintiff has culpable conduct, like if they step in a a raised tile in their own kitchen that they should know about. But if the tile is raised because of the defendant's negligence, right, and there's actual notice, like she sent them a letter and she says, hey, this tile is raised and they don't fix it, she could actually get summary judgment against them potentially because they're negligent, but then her culpable conduct, her own portion of blame goes to her damages. So then, instead of like say 100,000, it'll get reduced and maybe she'd only get 20,000 because she could have a large percentage of fault. So the plaintiff's percentage of fault doesn't go to whether the defendant was negligent, it just goes to the amount of the damages. And that's about CPLR 1411. There was actually a continuing legal education about that. So it's an interesting change in the law because it's a case called Rodriguez. It changed everything in 2018. And then since then, there's been like a lot of cases about that. So I was reading up about that. So there was a CLE about that, a continuing legal education. But yeah, like that's one of the ones that I remember losing. And unfortunately, we got no money for her. But sometimes, you have other cases where another lawyer in my firm tried a case on behalf of a kid, and there was a fire in the apartment. And, it was a tough case. And they were saying, look, there's nothing wrong with why the fire happened. He thought maybe it was the stove, but they said nothing wrong with the stove. It could just be that the parents were negligent and the parents had a lot of history of neglect and reports to the Administration for Children's Services. So he also lost. He got a 0, but he did one of these high lows. So even though he got 0, he was able to get like 250,000 on the low. So he still got a lot of money for the kid. So that's also what smart lawyers do. So they protect themselves. So if you think a case is going to go down, you still have that insurance of like, you do a high low. So if he would have hit for like 5 million, the most he would have gotten was 2. He had 2 million high, but he had like 250 low. So, or 275, I forget. It was many years ago. But anyway, but you protect the client and you still get them something. And then we have the super on a live stream from Ricey Harrier. Thank you so much. I appreciate that. And Frost says, if you have brain damage and medication makes your speech worse, seeing a neurologist, neuropsych, psychiatrist, and cognitive therapy, can you turn down mediation because your speech is so bad? Well, no. Like I said before, you don't have to go to mediation, right? What you do is you just you have the lawyer go to mediation. So the lawyer will negotiate that for you. But no, you shouldn't turn down mediation because mediation is a chance for them to pay you money and settle the case. As long as they're being fair, as long as they're negotiating in good faith and they're offering you real money, don't turn it down. Now, if they're not, if they're offering you like, pennies on the dollar, your brain injury, you're trying to get like 5 million and they're saying, oh, this is worth 15,000, then turn it down. But no, you don't have to worry about that. Now, with depositions, it's a little different, right? Because if you have a brain damage and you have speech issues, I mean, in one sense, you might want to present for a deposition to show, look, I'm not lying, right? I really have, and then they see, you could videotape the deposition, and then maybe they won't even get through the whole thing, but you could just do the first half hour and say, look, I can't do a deposition. And then at that point, your lawyer could file a motion to appoint a guardian ad litem, someone else to testify for you, like your son or your daughter or your wife or your husband, whoever, and then you claim that you have this disability that you're not able to answer questions. But I don't think it really hurts you because with a brain injury, that's such a serious injury that I wouldn't worry about that. I would focus, the case could actually be made bigger because you're showing how bad the injury is. And Ali says, hi, Arkady, my doctor is telling me I have a tear in my shoulder and a herniated disc, and the doctor is asking me to get surgery, but I am afraid of the surgery. Will my case still be worth fighting, even if I don't get the surgery? Yeah, I mean, you can still get money for it. It won't be as much as if you do get the surgery, but it could still have value. So the fact that you medically need surgery, but you're just scared to get it, that's like your own failure to then lessen your damages, right? Because you could lessen your damages and get rid of your injury by doing the procedure, but you're just afraid to do the procedure. So, the best thing to say is just like, I'm going to do the surgery. I'm just not ready to do it now for whatever reason. I'm too busy with work or family, or I have a lot of emergencies, but I'll do it later. I'll do it maybe like in 5 years. So then that way you have the need for surgery. It's just going to happen. And it's not going to happen now. So you can still get value for it, but it'll just be less. And then Moss Def says, how was your experience handling a personal injury settlement with Travelers Insurance after a car accident in New York City or Suffolk County, New York? Travelers, yeah, they're okay. They're fine. I've settled a lot of cases with travelers. I've had cases, yeah, in New York City. I've had cases in, I think, Brooklyn, Bronx. I don't do too many out in Suffolk because that's all the way out, like by Montauk and, out east. But I've had some cases in Suffolk. I can't really remember a traveler's case in Suffolk, but definitely in New York City, I've had a few. And I'm actually handling a few now as well. Yeah, travelers. And they're okay. I mean, they pay. Sometimes the same thing, right? They're not going to just throw money at you. Like right now, I'm thinking of a case. It's a pretty serious injury case, surgery, and they've already offered me like close to 800,000. But I said no. I want to get more. I want to get like at least. I think the case is worth maybe into the over $1 million, maybe like 1.5, 2 million. So I'm always trying to get as much as possible. Let me see. And then Ricey says, get the surgery, Ali. It's worth it, especially if your body needs it. Yeah, it's really a decision you have to make with your doctor. And then propose a solution says, having an impossible time finding a lawyer for maternal and petty med mal and negligence. I'm hopeless. They tell me to look for someone else and haven't looked at my records. Read statement of what happened. Oh, I'm sorry to hear that. Well, feel free to text me. Maybe I could try to help or find someone for you, depending on where you are and what the facts are. And then Ricey says, thank you, Arkady, for doing all this hard work for us. You are the only lawyer out there doing this free of charge to help the injured. That means a lot. Oh, thank you so much. I mean, I'm happy to help. I want to help as much as I can. So I try to take some time out to answer questions like this. And also I'm doing the consults as well. If you want to text me, we could do a private consult. And that's privileged, by the way. A lot of people ask, like, is it, I don't want my lawyer to find out, or I don't want my friends, or, it's not going to hurt your case, right? Because when you talk to me, it's just like talking to, it's privileged, meaning it's completely confidential. I don't tell anyone about it. So don't worry about that. And Propose says, if the lawyers around me are too busy to take my case, how can I find an expert to work with directly for medical malpractice, maternal, pediatric? It's hard to say. It depends on the type of case. Usually it's hard to find an expert for something like that on your own. You probably want to get a lawyer because it could be very expensive. And then someone asks, how possible Amazon van with commercial license plate has 25K policy? Oh yeah, well that's what I was talking about actually earlier in this video. I don't think it's possible. I think, I think it's just they're playing games. That's one of the ways the insurance companies try to play games, because they say, well, it's not an Amazon van, right? It's just another company that like does business with Amazon. So kind of like an independent contractor. And there's a lot of case law as to whether you are an employee or an agent of a principal, which is like Amazon, or you're an independent contractor. And if you're completely independent, you could have, ABC messenger service. You just kind of work with Amazon, but you might work with other people too. And then, you only have 25,000. But I don't think they can do that, because if you're delivering Amazon packages, from what I've seen in other cases, and I've done videos about it. I did a video about a case out of South Carolina. It went for 44 million. And there was another case involving Amazon, these delivery service partners. And that one, I think, was like 16 or 20 million. And there was actually a recent CLE where they did a video and they gave all these like notes and handouts, all the factors and how you prove that Amazon is responsible, and you get Amazon's policy in play. But I think that even the other company, the DSP, has to have at least $1 million, right? Or has to have, because it's like a truck or a van, it's a commercial vehicle, it's got to have commercial limits. It can't have 25. So I was just saying I've seen that, but I think that's just one of the ways that the insurance companies try to, scare you or kind of like, not pay. It's not fair. And then Leonardo says, what does it mean when jury selection outcome says closed and the settlement conference says held on the same day and the court assigns jury selection for another date? Is it not supposed to be trial the next step? So it probably means you had the settlement conference and then the jury selection didn't happen, right? Because you can't have both at the same time. If you're doing a settlement conference, you can't be picking the jury. So probably they adjourn the jury selection, and the jury selection will be like in a few weeks or at the next date. And then Christopher says, hi, super lawyer, 2 depths. Wait, maybe I went down too far by accident. Go back up. Oh, here, okay. Hi, super lawyer. 2 deps done. Cervical C5-6 done. Recommend lumbar as well. Truck crash, 1 million tractor policy, 750 trailer. What are your thoughts? We have a conference in April, Westchester County. Yeah, I mean, look, if you have C5, C6, like fusion or disc replacement surgery, and you need a lumbar as well, that should be worth the policy, I think. If you can get 1.75 or 2 million as a total aggregate, I think that's worth the policy. Why not? I mean, that's a serious injury. That's very serious. Westchester County is a tough venue. It's not as good as like Bronx, but you can still get good money. I did a trial there also in the fall, and it was a fusion case, but it was an aggravation. The case had some issues, and I think we ended up settling the case. We got it at the last minute. It was more like we came in as trial counsel. We kind of got it a month before trial, so we couldn't really change it. But we ended up, I think we got about close to 700 on that case. But in your case, if it's a clean case and if there's no issues, I think you can get into the millions for sure, maybe even the full policy. Okay, and then Lost in Awareness says the defendant's lawyer in my case made a proposed order of protection from court appearance. Does that mean they're trying to get him not to come to court during the trial? Yeah, exactly. An order of protection just means like if you're asked for like a deposition and they say we're filing a motion for like protective order, it just means that they want the judge to say that you're not entitled to that deposition or you're not entitled to question that witness. But usually there are rules about that. So it depends on how the judge decides it. And Come Along with Uncle Joe says, due to several surgeries years ago, I lost my seniority. I no longer make, let's say, $10 now. I make $3. Oh, I see. You lost your like seniority in the job, and so your pay is less. Yeah. So if that's part of your lawsuit, you could add that to your lawsuit. That's part of your damages. And Joe says, slip and fall in New York City Housing Authority building with injury resulting in surgery. Initially had a lawyer, but switched to a new lawyer due to lack of communication. Court date missed during switch, causing dismissal. Oh, okay, that's not good. Well, what you could do is you could have the new lawyer just file a motion to restore. They should restore. You just explain, hey, it was like in between lawyers and there was nobody there, just missing one court date. That's another thing, right? You miss one court date as a plaintiff, they dismiss your case. Now, you show up to court as a plaintiff, and guess what? The defendants don't show up. Their law firm does not show up. You know what the judge does? Oh, just adjourn it. Come back. Like if I had a court date today and the defendants don't show up, they're not going to dismiss against the defendants. They're not going to strike their answer. They're just going to say, oh, come back in April. It's actually a good thing, right? They could just sleep and not show up. They can't do it over and over again, but once or twice, and there's no penalty. But if a plaintiff doesn't show up, oh, dismiss the whole case. That's fair. That's crazy. So Moss Def says, thank you, Arkady, for answering my question. Oh, you're very welcome. And Marquita asks, I know my case is valuable, but personal injury is so unpredictable, especially in conservative venues. Insurance companies can make injured people feel like money-hungry bums. Yeah, unfortunately, I mean, they really should be more fair, but unfortunately, they're not. But you're not really hungry for money, right? You're not really looking for a payday. You're just looking for, I mean, if you can get your health back, you would get that, but you can't. So you're just asking for the fair, equal trade dollar value of everything they've taken. And it says, I know the corporate veil would need to be pierced. Oh, no, I'm sorry, I missed it. Hi, Arkady. When I look online, it says when the owner of an LLC uses the LLC car and causes an accident while on personal business, it says you can sue both the owner and the LLC. Your thoughts? Yeah, I mean, I agree. I think you should be able to sue if the LLC owns the car, you could sue both. And it says, I know the corporate veil would need to be pierced. The LLC entrusting the LLC registered car to the owner makes the LLC at risk. Yeah, it's basically like pretty simple because it's just like the owner of the car. If the owner of the car is the LLC, and if it's the individual owner, if he's like the owner of the LLC, you could sue the LLC as well. But it depends on the law in your state. Every state will have different law on that and different precedents. So probably best to ask your lawyer to research that and to make the argument in your state. And Sandy says 150 to 200K just for an arthroscopic surgery, or is that the average? I I've seen it. It depends on like the overall like impact to someone's life, right? If they've just had like say a simple arthroscopic surgery and everything healed and they're completely better, it might be a little less. But if they have the need for a future surgery, right? Like I had a client who had a knee arthroscopy, but then because he favored the other leg because his knee was injured, then he needed a surgery on the other leg. And then they said, oh, and now because of that, then the original leg needs a total knee replacement. Now he didn't have the total knee replacement, but he needed it. And he had a letter from the surgeon saying he needs it. But all he had was one knee surgery. But now he had injury to the other leg. He had a need for a total knee. And I think we settled it for like $750, that one, because of all these, permanent injuries and consequences. So it just depends on the damages. The more damages, the more compensation. And Joe says, what is the average settlement for a New York City Housing Authority slip and fall downstairs with the injury and surgery? Yeah, well, that'll depend on the type of surgery and also how you fell down the stairs, the type of liability. If you can show notice and you have strong liability, or if you could show they caused and created the condition, then that makes it a lot stronger. And if you have like, it depends on the surgery. Like if it's a knee scope, it could be like, 100, 200. If it's like a fusion, it might be, more like close to $1 million or more. So it just, there's no such thing as an average for an injury or surgery. It just depends on which injury, which surgery. Every injury has specific amounts. And Richie says, I've had 2 disc replacements in my neck and spinal fusion in the lower back. Uber hit me while they had passengers. Case value in Miami-Dade. So 2 disc replacements in the neck and a spinal fusion in the lower back. I would think, if it's Uber and they have enough insurance, I would think it could be worth into the millions easily, because that's a serious injury. And spinal fusion, very serious.